Good afternoon and welcome to the Office of Tax Appeals. My name is Judge Veronica Long, and this hearing is for the appeal of EWV LLC et al. We are broadcasting live on YouTube. However, the hearing record has not yet begun. This hearing is anticipated to last about 2 hours and 15 minutes, so we're going to take a 5-minute break after appellant's presentation. As stenographer, Ms. Alonso is present and reporting this hearing verbatim. To ensure we have an accurate record, we ask each person speaks one at a time and to avoid speaking over one another. Also, please speak clearly and loudly. When needed, Ms. Alonso or any panel member will interject to ensure proper transcription. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the OTA website. As a reminder, the Office of Tax Appeals is not a court, but it is an independent appeals body, which is staffed by subject matter experts and is independent of any tax agency. While the OTA is not a court, we must nevertheless follow certain guidelines to ensure we establish a proper record on which a decision is based and to conduct an orderly hearing. Each party will have the opportunity to be heard, so we ask that you please wait for your turn to present your side. And with that, are there any questions about anything that I have just said before we go on the record? I'll begin with the appellant's counsel. Any questions before we go on the record? Looks like you're muted, Mr. Lenz.
You said Pons, what you call Pons? What's respondent? Did you say Pons counsel?
I said appellant's counsel.
Oh, appellants. Oh, okay. Yeah, everything's understood. Thank you.
All right, thank you. Franchise Tax Board counsel, any questions before we go on the record?
No.
All right. With that, I'm going to confirm with my panel members and with our stenographer that we're ready to proceed. All right, I see heads nodding. Great. With that, we are going. Oh, one moment. All right, with that, we are going on the record. This is a hearing in the consolidated appeals of EWV LLC, Abady, Hashem, Kanani, and Abrams. OTA case numbers 220-811-162, 220-811-131, 220-811-196, and 220-811-163. The date is April 4th, 2025, and the time is 1:09 p.m. This hearing is being held electronically with agreement of the parties. I am Judge Veronica Long, and I will be the lead panel member for the purpose of conducting this hearing. My co-panelists, Hearing Officer Elsom and Judge Keith Long, and I are all co-equal participants in deliberating and determining the outcome of this appeal. I'm going to ask the parties to identify themselves and who they represent, beginning with Franchise Tax Board.
My name is Carolyn Kudak. I represent respondent.
Blake Cunningham, also represent respondent, Franchise Tax Board.
And appellant's counsel?
Norman Lenz representing appellants.
All right, with that, I'm going to confirm the issues to be decided in this appeal, which are the same as those stated in my minutes and orders. First, whether appellants must recognize taxable boot in relation to an Internal Revenue Code Section 1031 exchange. And 2, whether appellants have demonstrated they are entitled to interest abatement. Next, I'm going to discuss the exhibits in this case. Appellants submitted exhibits 1 through 22. FTB did not object to exhibits 1 through 20, which were presented prior to the pre-hearing conference. FTB, do you have any objection to exhibits 21 and 22, which were submitted after the pre-hearing conference?
No.
All right, with that, appellants exhibits 1 through 22 are now admitted into evidence. FTB submitted exhibits A through U prior to the pre-hearing conference, and appellant did not object to the admissibility of those exhibits. Therefore, exhibits A through U are now admitted into evidence. I'm going to ask each party if you have any new exhibits today, beginning with Mr. Lenz.
Do not.
Franchise Tax Board?
No.
Great, thank you. With that, Mr. Lenz, you may begin your presentation. You have 60 minutes. Begin when you're ready.
Thank you so much. Again, I appreciate, and with the taxpayers, the appellants appreciate the opportunity to present our case to the judges on the panel. Just on the outset, I want to point out I'm not a litigator. I'm a tax lawyer, and don't. This is actually I've been a tax lawyer for now over 27 years, and this is my first litigation where I'm actually acting as a litigator. But I apologize in advance for any faux pas or any rookie errors. Being the end, this is not my area of expertise, but again, I do have an area of expertise in the subject matter, but not necessarily in all the procedural rules. I will try my best. I've tried to learn from others what I need to do and how the procedural aspects work, but just letting everyone know that that's not my not my comfort zone. But
Mr.
anyway,
Lenz, I will ask for one thing. Our stenographer is transcribing everything you say. You're doing very well so far. Just slow it down a little so that
sure.
she's able to copy what
Okay,
you're saying. Thank
fair
you.
enough. Okay, not the first person told me I speak fast. But the clients love it because they pay by the hour. So if I talk faster, they pay less. But anyway, uh, there again, there's ultimately three issues, but they're really there's the two issues. One is the interest abatement, which we'll save for last. There isn't that much to talk about that. The bigger issue, of course, is the boot, and that taxable issue really has two subcomponents. One is the boot from the escrowed funds, and the second is the boot from the loan expenses. From a monetary perspective, the escrowed funds, the issue there is a much more significant amount. So I'd like to begin focusing on that. Although the respondent in their opening brief kind of started with the loan expenses, I'd like to reverse it and start with the discussion of the escrowed funds because that's where there's a more significant amount. Not that the loan expenses are insignificant, but relatively from a financial perspective, they're less significant. So I want to make sure I spend more time on the escrow issue than on the loan expense issue. Within the issue of the escrow funds, I'm a little bit unclear exactly what FTB's position is, but I certainly did see on their pre-hearing on their submission is that they believe that there's really an issue with respect to both actual and constructive receipt of the escrowed funds, and just that we're all understanding, well, my perspective of what actual and constructive means. Actual receipt means that actually the money actually came in to the taxpayer's hands. Constructive receipt means it didn't actually come in to the hands of the taxpayer, but because the taxpayer had an open door, had full access to those funds, that's treated, although they did not actually receive them, but since they could have received them, those are treated as having been received as well, constructively received. And there's a difference between actual and constructive. Yeah.
Mr. Lenz, I'm just going to ask you if you could slow it down just a little
Sure.
bit, please.
Okay.
Thank you.
Okay. Sure. Apologize again. So again, the difference between actual receipt of funds and constructive receipt of funds is whether the money actually comes into the hands of the taxpayer versus it didn't actually constructive receipt is the way that they didn't actually come into the hands of the taxpayer, but the taxpayer had full access, had the ability to access those funds. So, for example, actual receipt of funds, if the money came from someone's account and was wired to the account of the taxpayer, that's actual receipt. Nothing to talk about there, really. Constructive receipt is where the assets, the cash, didn't actually come into the account of the taxpayer, but was offered to the taxpayer, and the taxpayer had the ability to receive them and turned its back on those funds and refused to receive them, whereas then the tax rules in that context will say, well, look, even though you didn't actually receive them, they didn't hit your account, but because they were so accessible to you and there was nothing stopping you from getting them, the tax law will then treat them as if they had been, in fact, received by the taxpayer. Classic example would be it's December, and happens all the time. We get this all the time. A boss comes to the employee December 31st, says, here, I want to pay you a bonus. Here's the $100,000 bonus. Here's the check. And the employee says, no, you just leave it in your desk right there. And I don't want to take it. Give it tomorrow. Let's deal with it tomorrow. And the boss says, okay, it's right here. I'm leaving for the day. Come and have a happy new year. Come and get whatever you want. That's constructive receipt because in that situation, although the taxpayer classically turns his back or her back on that cash, which was fully receivable in December 31st of the earlier year, and the taxpayer turned its back on that money, that's constructive receipt. Actual receipt is when you actually get the money and have it in your account. And the reason why I'm spending an inordinate amount of time on this issue is because I'm not entirely sure what the FTB's argument. In some places, they say they're arguing that we had actually taxpayers here had actual receipt of the cash, but their main argument seems to be constructive receipt. But I do want to deal with both of those because there's some lack of clarity on what precisely the FTB's position is. We will address both of those points. Again, in terms of actual, I don't think there's much to talk about there. We will discuss it. There was no receipt of the funds. The funds went straight to the escrow account, and there was no receipt until 2017, 2018, 2019. In those later years is where the funds were received. So we don't believe there should be much of an issue about actual receipt, but because it's been raised and mentioned, we will address it as well. Constructive receipt, that is where I believe the main argument is, the issue being, yes, assuming we don't have actual receipt, but there was escrow funds that were put into an escrow account, and that's where I believe we have a point of contention with the FTB, where the FTB says, well, those funds in the escrow account did not really have any significant restrictions that would have prevented the taxpayer from accessing them. They're like the employee, my example, who just turned his back on the check and said, I don't want it, but could have easily taken it. The FTB's position is the same thing here. These funds were in this escrow account, but there was really nothing stopping them from accessing those funds. And because there were no significant restrictions on the taxpayer's ability to access those funds, FTB believes the taxpayer had constructive receipt of those funds. And that, again, is a point of contention, unlike the actual receipt issue, where I think there's really not much to discuss because it never hit our account. The constructive receipt issue boils down, in our view, to this discussion of whether there were, in fact, these substantial restrictions placed upon taxpayers' ability to access the $4.5 million of escrowed funds. Okay. In terms of how I'm going to present I would like to, again, with the permission of the honorable judges, to go through, to follow, in effect, the write-up we originally submitted August 15, 2022, which is one of the exhibits. And then once I've done that, I'm just going to summarize, because sometimes some of these positions or arguments may be in writing harder to understand and comprehend than they are perhaps verbally. So I'll make an effort in cases where perhaps the writing wasn't as clear as it could have been to present a verbal summary of some of those arguments so that we're clear about what we're arguing, what the FTB is arguing, and be able to reach an appropriate conclusion. Once that's done, I would like to go through some of the respondents' opening brief and our response to that. And the same idea of, yes, we've responded in writing, everyone's seen those submissions, but we'd like to perhaps explicate further and explain some of those things that are in writing in case there's a disconnect between the written word and the oral word, and perhaps through discussion and oral presentation, those points can become clearer and more comprehensible. So I'm also not, I don't want to waste all of our time just talking about points that we all agree on. I think we all fundamentally agree with the facts of the case, that there was relinquished property sold, and there were proceeds from that relinquished property that went to a qualified intermediary account. I don't think the FTB is not questioning that and has not questioned that. And no one's questioning the fact that there was a valid QI account, and then there were sums that were deposited there, and those amounts went ultimately to the account of the seller of the replacement property. But again, I do want to try to focus on those areas where we do have points of disagreement in terms of both the escrowed funds, whether there was actual and or constructive receipt thereof, and the nature of the loan expenses, whether they should or should not be treated as boot. From the economic perspective, again, maybe some of the confusion perhaps relates to the presentation on the settlement sheet. But again, I think fundamentally, we're all in agreement, in fact, that there was that the purchase price for the replacement property was, in fact, $54.5 million. That was the purchase price. And the amounts used to pay that 54.5 purchase price was $45.5 million of loan one, and then roughly $4 million of a second loan. That's the $8 million. That's the $8.5 million loan. Part of which, again, $4 million of which was used towards the purchase of the a replacement property, and some of it was used and it was escrowed and used thereafter for tenant improvements, capex, leasing commissions, all the things that a real estate owner does to improve property. But that's again an important fundamental distinction. That basically, when you run the numbers, we've got a total alone really for the initial purchase for the purchase price of the property as is, if you will, was $49.5 million, which is and that $49.5 million was funded with a $45.5 million loan called the Loan 1, and $4 million out of the $8.5 million loan. $4 million was accessed initially at the closing date for a total of $49.5 million, which leaves you with $5 million of equity, which was the amount that was rolled over from the original property, from the relinquished property into the replacement property. Now, again, we'll this is in the record as well in some of the exhibits, but that's kind of big picture what happened. I'm not sure if there's that much factual disagreement as well about those points so far. That $4 million was used towards the initial purchase, and the other $4.5 million was in fact escrowed. There may be a question of conceptually, was that the second $4.5 million, the escrowed amount, did that come in and go out? Or did we do disagree about whether the taxpayer had full access to those funds or not. But I think on those fundamental numbers, I believe, again, the FTB will have the opportunity to respond later on, that those numbers are agreed to, that there was money paid for the property initially as is, and there was more money that was escrowed from the loan that wasn't accessible immediately, but was usable and in fact was accessed over a period of 3 years to fit up the property, to provide tenant improvements, to provide pay leasing commissions, and to do capex work on the properties. That's that kind of the way we're viewing it. So now, again, I'm not going to go through all the details, but if you look at the escrow agreements, there were clearly conditions that needed to be satisfied in order for the taxpayer to access those funds. So again, we had $49.5 million of loan amount at closing, $5 million of equity, and that was all to buy a property worth $54.5 million. And then there was $4.5 million of escrowed funds that were placed into escrow, and the issue becomes, what level of access did the taxpayers have to those? And if you look at the escrow agreements, and I think FTB is aware of this as well, there were in fact certain things needed to happen before the taxpayer would have the right and the ability to access the funds. They needed to lease up the property with leases that were satisfactory to the lender. The leases had to have a term of 5 years or more. They had to actually spend money, had to actually pay the leasing commissions. They had to deliver lien releases, estoppels. Again, I'm a tax attorney, not a real estate attorney, but I've consulted with my real estate colleagues, and these are not unusual provisions in an escrow agreement that provides that in order for the taxpayer to access funds, they need to do certain things, need to meet certain conditions, and in no way do these restrictions represent rubber stamping and like, okay, just sign the check, give us the money. These are real things, real conditions that need to be met in order for the taxpayer to access the funds. And we'd like to kind of go through that. So again, going back to the economics of the transaction, we bought property worth $54.5 million with a loan of $49.5, and then we had the ability to access $4.5 million more to invest in the property and thus bring the value of the property up to $59 million. We also want to mention there is a case, Fredericks versus Commissioner, which is very close to our facts, which also addresses in the context of like-kind exchange, that escrowed funds that are not accessible with ease by the taxpayer, that have conditions attached to them before the taxpayer could access them, do not represent taxable boot. And that's the case of Fredericks v. Commissioner, TC Memo 1994-27. Okay. Okay. In terms of what the rules are, the rules and the regulations, and there were some discrepancies between the FTB's position, whether they were looking at the 451 regulations or the 1031 regulations, but I don't believe any of that is material. At the end of the day, all the regulations and all the case law pretty much says the issue of constructive receipt is that a taxpayer is treated as receiving property constructively if it has the ability to draw, if it's credited to the taxpayer's account, if the funds are set apart for the taxpayer, or they are otherwise made available so that the taxpayer may draw upon them at any time with no significant restrictions. And the U.S. Tax Court has said that the doctrine of constructive receipt is effectively a fiction, and therefore it has been cautiously and sparingly applied. That's a quote from Millsaps versus Commissioner, TC Memo 1973-146. So it should not be applied unless there's very strong evidence that there has in fact been constructive receipt. It's not something that gets used unnecessarily or in situations where it's not appropriate, of course. And there are many cases out there that stand for the principle, and we went through them in our original protest, where the cases say that if there's funds in an escrow that are not accessible, if there are funds in escrow that have conditions that must be satisfied in order for a taxpayer to receive them, they have not yet been constructively received. Okay. So that's basically the concept of constructive receipt. And now I want to talk about how that would apply here. But first, before we go there, I want to discuss the potential that there's been actual receipt. Because again, as I alluded to earlier, the FTB appears to be arguing a multi-pronged position. Number one is that there was actual receipt of the funds. And then even if there wasn't actual receipt, I guess the secondary argument is that, well, there was constructive receipt. So before we apply the laws of constructive receipt to our facts and discuss the restrictions that applied, I want to just talk for a moment about the actual receipt and maybe perhaps why. Again, I will, FTB will have its opportunity to present its case, but we strongly believe there was no actual receipt, and we strongly believe there was no constructive receipt either. I believe that perhaps the position of the FTB is based upon the fact that the settlement sheet seems to indicate that the loan funds were hitting on the settlement sheet the entire amount of the loan, which is the 49.5 plus the 4.5 for a total of 54.5. The settlement sheet appears to indicate that entire amount came in. And that may or may not be true, but practically speaking, it didn't. In other words, if it came in, it went right out, because on that same settlement sheet, where the 54 million is shown as a credit, there's also a debit for the 4.5 million, which went to ANIC, which is the escrow agent. So again, if that's the source of why the FTB believes that there was actual receipt because of that credit on the settlement sheet, that's really a misnomer, because the same settlement sheet that shows it coming in shows it immediately going out, so that never ever was accessible to the taxpayer, because it was all pre-wired and required. The lender is not allowing the taxpayer to walk away with that 4.5 as part of the pre-wiring of the closing. That money was in and as a credit and out immediately, required to go out immediately to the escrow agent, such that the taxpayer did not have any access to it. And therefore, we don't believe that is in any way indicative of the fact that there was actual receipt of that money. And again, as we've shown through the bank statements and the loan statements, that money actually was accessed. The 4.5 million was accessed over a period of 3 years as the taxpayer did its construction work and did its tenants improvements and did its leasing. They were over time, and we've tied together the numbers showing how that 4.5 million came in over that period of time, but did not come in. Although, again, technically it may show up as a credit on the statement, but that same statement has it going out as a debit to the escrow agent, which is exactly what happened. The other possible source of confusion. Perhaps we thought maybe it was some language in the escrow agreements which imply that the money is coming to the taxpayer, and then the taxpayer is going to contribute it to escrow. Again, that language, may in fact have been there, but again, that's not what happened, and that's the lender would never have allowed the taxpayer to walk away with that money. The lender wants that money to be in escrow, and therefore, notwithstanding such language, that doesn't affect the reality of what actually happened, which is at closing, the money in effect came in and went straight to the escrow agent from the lender, and the taxpayer therefore never had any access to it. And the fact that the documents may imply that that it's happening in a two-step process, and or the fact that the settlement statement may imply that there was some sort of receipt, there was not in actuality any actual receipt of those funds. Which makes total sense, because a lender is not going to want a borrower to have the money and say, hell, count on trusting the borrower to give the escrow money back. They're going to require that money to go straight to escrow, which is in fact exactly what happened. So it was not credited to EWV's account. It was not set apart for EWV for the taxpayer. And they were, in fact, as the escrow agreements say, they were held in an unsegregated, non-interest-bearing, unsegregated non-interest-bearing accounts of the escrow agent, and therefore, of the lender, and therefore subject to all the claims of the creditors of the lender, but not subject to the claims of the borrower of the taxpayer. So therefore, we don't believe that there's any argument that there's actual receipt of those funds. Now, with respect to constructive receipt, there's room for legitimate disagreement or questions that, again, actual receipt there wasn't. That's factual in our view. Constructive receipt becomes a legal issue, that's not a factual issue. In contrast to the actual receipt, which is factual, constructive receipt is a legal issue as to whether there were sufficient restrictions to the taxpayer's ability to access those escrowed funds for the tax law to consider them as having been received and accessible to the taxpayer, and therefore treated as taxable boot. Again, we mentioned a few of them before, but I guess I'm really struggling to understand how there could even be an argument that these restrictions that are in the escrow agreements are not substantial. I mean, these are clearly obligations and conditions that are not in the hands of the taxpayer, EWV itself. There are many things that others must do in order for the taxpayer to be able to prove to the lender that it has met the conditions and is therefore worthy and entitled to receive distributions and disbursements of those escrow funds. For example, in the leasing commission escrow, they've got to find tenants. That's not always easy to find tenants, and those tenants must be approved by the lender. And they must enter into leases, which are 5-year leases. I mean, there are all sorts of risks involved. If there's a real estate meltdown, if there's a big recession, you're not going to find tenants. I mean, if there's a COVID epidemic, all sorts of things that can happen could prevent the taxpayer from being able to satisfy those restrictions, those conditions, and being able to find appropriate tenants, to be able to get lien releases from workers, estoppels and subordination agreements from tenants. Now, again, I'm not a real estate person, but I did speak to my real estate colleagues, and they assure me that, yeah, these things are real conditions. These are not rubber stamped. These aren't things you just say, snap your fingers and get. These are real serious conditions that need to be met in order for the taxpayer to be able to access the funds. More so, and not easy lifts. Tenant the CapEx, I mean, the way the agreement works is they have to first spend the money and then show the receipts to the lender. Again, that's something which is not that easy, not in any way, shape, or form. Are these conditions rubber stamp items or things that are easy lifts? Some are quite difficult, and in fact, it took the taxpayer 3 years to meet those conditions and access disbursements of those escrowed funds. This is very different from the taxpayer in my example on December 31st, who turned its back on the check that the boss offered, and just said, "Put it at the desk. I'll come and get it tomorrow when it's a new year, and give me deferral to next year." This is not that at all. They were not able to access the funds, and the lender, frankly, wouldn't have let them have the funds because, again, the lender wants that money to be used for improvements, which increase the value of the property, of course. Tenant improvements, getting tenants itself, getting into leases, leasing the property. We all know a fully leased building is worth far more than an unleased property, and therefore satisfying all these conditions in order to improve the value, to increase the value of the property, something that the lender would have insisted on and would not have allowed the tenant just to take the money and do things that would not increase the value of the property, such that its loan amount is secured by greater value put into the property. So under these circumstances, we don't understand how the FTB could argue that the escrowed funds were essentially the property of EWV. Again, there were significant conditions and restrictions on their entitlements to the money. The money was in unsegregated accounts of the lender. The lender these funds were not segregated out. The lender, its creditors, were able to access those funds, whereas the taxpayers' creditors were unable to access those funds. That's specifically in the documents, and that's why we don't believe that we believe that there was not constructive receipt of these funds that were in the escrow. Now, we saw this argument made originally by the FTB way back when, and it was made a second time in the in respondent's opening brief, that there's a provision in the escrow agreements that says that the lender's approval for disbursements could not be unreasonably withheld, conditioned, or delayed. And I think the FTB is interpreting that to say, well, you see, the lender had no choice. They basically had to rubber stamp any request for disbursement by the taxpayer would have to be, under that provision, would have to be given to this taxpayer, because it would be unreasonable to withhold those funds under those conditions. But that's just not correct. What the agreement is saying is that after the taxpayer satisfied the onerous conditions that were necessary for it to access the escrowed funds, at that point, if it had satisfied its requirements, then the lender could not unreasonably unreasonably refuse to disperse funds, because the taxpayer has satisfied the conditions that have been placed on the escrow. But that's not the same thing as saying that under all conditions, whether or not requirements are met, the lender must disperse the funds. That is not at all what the documents are saying. And I think there may be a misunderstanding. That language is, again, only upon the satisfaction of the conditions and the requirements. That's when the requirement of the lender to disperse cannot be unreasonably withheld. But that does not in any way, shape, or form indicate that somehow it was an automatic access to the funds, which seems to be what the FTB was arguing. One other point, again, I think we saw the FTB making, was that the escrowed funds could be used to pay off the loan. Now, that, again, I've checked this with my real estate colleagues. That's a very standard provision, and it only applies if there's a default on a loan. That's when that provision applies, and that's, again, in every escrow agreement, and that's very standard in every loan agreement, that whenever there's, God forbid, a default, all hell breaks loose, and all sorts of stuff like that happens. You accelerate their payments. We're not giving you any more escrow funds, which makes we're not going to give you any more escrow funds. If you defaulted, of course, we're just going to take all those escrow. We have the right. The lender has the right at that point to take all the escrow funds back. Because you're being a bad boy. You're being naughty. You're not paying back your debt. You've defaulted. So of course the lender is going to say, okay, all bets are off now. We're taking those funds back. So that is not in any way indicative that somehow should mean that the borrower should have constructive receipt of those funds, because that's a standard provision in every loan agreement when there's a partial escrow, is that if there is bad things happen and there's a default on the loan, at that point, loan is basically closed out and all the money comes back, and there won't be any more for further disbursements of the escrowed amount. So again, we don't consider that in any way indicative of constructive receipt. And in fact, if it would be, pretty much every escrow would be treated as constructively received and would be treated as boot to a taxpayer or taxable income under other circumstances, because that's standard language in any escrow agreement in connection with a loan. So again, that's basically our view again on the issue of escrowed funds being actually or constructively received. And just to summarize, we don't believe they were actually received because they weren't. As a factual matter, we can show that they were dispersed in later years. The fact that there may have been a line on the settlement sheet showing that it came in, that same settlement sheet on a different side shows they went immediately out, and that was all pre-wired to happen, and there was no ability of the taxpayer to pull those funds out. And the fact that there may be language in the escrow agreements that imply that it's technically going to the taxpayer and then the taxpayer is sending them to the escrow. Again, that does not change the reality of the facts on the ground, which is clear that that money went straight to Anik, the escrow agent, and that money was held there and never hit the taxpayer's pockets, and therefore should not be considered actually received. And again, we don't believe that they were constructively received either, because again, there were very significant restrictions, things that needed to be obtained from third parties that were not in the hands of the taxpayer at all, that were dependent upon other people who may or may not have been willing or able to do the things that were being asked for. And if that would have happened, then there would have been inability of the taxpayer to get those funds. And again, I point out, if it was so easy just to snap their fingers and get the money, they would have taken it all right away. I mean, most of my clients, they want to get money, as soon as they can. And why'd they wait 3 years over time, right? Why don't they just take the money and run initially and invest it and make more money on it? The answer is because they couldn't, because there were restrictions and conditions that had to be met. And without meeting those conditions and restrictions, they didn't have access. So both on the issue of actual receipt, we believe the position is strong that there was an actual receipt of the escrowed funds. And with respect to constructive receipt, which is a legal issue, we believe the restrictions in place were sufficiently strong and out of the hands of the taxpayer, such that the taxpayer did not have a constructive receipt of those assets. So that's our presentation on the issue of escrowed funds. On the other issue of the loan expenses, again, moving over to the second issue, and that's divided, that itself is divided into two separate amounts. There was a $540,000 prepayment fee, which is actually not technically it was really a fee paid by the taxpayer to be allowed to prepay the debt, because it was respect to the new loan, and it was a 1% fee paid, and that's one that's one fee which we believe does not represent boot, which the FTB believes does represent boot. And then there's a $340,000 of lender legal expenses that were paid, and the issue there becomes, one is a factual issue and one is a legal issue. The factual issue is, were those amounts paid from the QI account? And if they weren't paid from the QI account, for example, the $540,000 was not paid from the QI account, it was just a reduction of the loan. So instead of loaning 100% of the loan amount, the lender really effectively, because it took this 1%, it withheld the 1% fee, it really only lent 99% of the loan amount, keeping 1% for itself. This is factual, the way it worked on the 540. This is not factually how it worked on the 341 of lender legal fees, but this is the way it worked on the 540 of prepayment fee, that really just was a reduction of the amount that was loaned. That money did not come out of the QI account. And if that money did not come out of the QI account, we don't see how that could be taxable factually. Again, not legally, just factually. All that amount represents a smaller loan. The lender basically said, we're taking out of this loan amount, we're taking out a 1% fee to allow you to prepay it. And again, since it did not come out of the QI account, it just was a reduction of the loan amount. We don't see how that could be taxable boot. The 340, and that's just, before we get to the legal issue, that's just on the factual side. The 341, in fact, did come out of the QI account. And by the 540, by the way, again, you see that not coming out of the QI account, because you see that from the settlement sheet. It's treated as a debit on the settlement sheet because it effectively reduced the amount of the loan that was received from the lender. The 341,000, that in fact factually did come out of the QI account. So there's no, but at the same time, our belief is that that shouldn't, on the factual side, since funds and cash is fungible, it shouldn't really make a significant difference whether it shouldn't really hurt the taxpayer from the fact that they took it out of the QI account. It's still, we believe there's an argument that still should be viewed as effectively a smaller loan amount. Because then cash is fungible. This money came out, they borrowed more, but it's just an amount that had to be paid in order to get the loan, and they needed the loan in order to purchase the replacement property. And therefore, we believe that because cash is fungible, since it could have just as easily been done as a reduction of the loan as well, but rather the taxpayer chose to pay it from the QI account, that shouldn't fundamentally affect the analysis. That ultimately what happened is they really got a smaller loan because there were fees associated with getting that loan, 341,000 of lender fees, the 540,000 of prepayment fee. Am I talking slow enough, or too slow, or fast? How am I doing on the pace?
Mr. Lenz, you're doing fine. You are welcome to slow it down a little bit. We
Okay.
have only this hearing on our afternoon calendar, so we can
Okay.
give you a little more time if you need it.
Okay.
But slower is always better for our stenographer. Thank you for asking.
Thank you. Okay. So that, I guess, again, on the factual issue, we believe the 540 is really off the table because that was not paid from the QI account at all. In fact, as we'll see later on, I believe FTB concedes that point. That was actually just reduced the amount of the loan paid by the lender. And the 341, that amount we concede was actually paid from the QI account, but because it could have just as easily reduce the loan, it shouldn't conceptually make a difference, and it should also be viewed conceptually as an expense which effectively reduces the amount of the loan. That's what we believe on the factual side. On the legal issue, so now on the legal issue again, just in terms of conceptually, there's the factual issue which we just discussed, and the legal issue which is very distinct, which is, let's say that it all, conceptually, you don't buy my argument that it really is a reduction of the loan. You believe it really, the loan amount was the full loan amount, and this is money that came out of the QI account. So even if you go arguendo with that approach, from a legal perspective, we believe that there's a strong argument, although this point has not been developed in the law, and there is no case law explicitly on this. It's a gray area, we can see, but we believe there's room because of the fact that no court has ruled either way on this. We believe the arguments is pretty compelling that this is the way it should work. That these expenses, because they're loan related, and without the loan, the replacement property could not be acquired. Because of that connection and that necessity, we believe that it's legitimate, even if they would have taken all these amounts out of the QI account, and you don't view them as reductions of the loan, but you view the loan as being the full amount, and these amounts coming off are really just expenses paid out of the QI account to obtain the loan. We believe because the replacement property could not be acquired without a loan, that should mean that these expenses are in fact exchange expenses that should be viewed as legitimate expenses that you're allowed to pay with QI funds, because the general principle is any amounts you need to acquire the property and ancillary amounts, for example, recordation taxes, title searches, all those things that that normally go into the basis of the replacement property that's acquired, that I think even FTB concedes those amounts are allowed to be used to be paid out of the QI account if they're amounts that are paid in connection with the acquisition of the replacement property. And we believe a loan which is needed in order to acquire the property should have that same treatment as other expenses that are necessary to acquire the replacement property. Now, again, there's no case that explicitly makes this argument, but there's also no case that says that it's not correct either. So it's kind of a new area of the law, and I've seen practitioners go both ways on this, but we believe the better answer is, again, even if we lose on the factual issue, and it's argued that this really were expenses that were not just reduced the loan amount, but in fact were expenses paid out of the QI account. We believe that because of the fact that, but for the loan, the acquisition of the replacement property couldn't occur, that these expenses should be treated no differently than other exchange expenses that everyone concedes are allowed to be paid from the QI account. Now, one thing the FTB seems to argue is that because of the fact that these amounts are normally capitalized as opposed to being written off, that seems to be indicative to the FTB that they cannot be exchange expenses that come out of the QI account. Now, we do not agree with that. That, as a matter of law, is not correct. In fact, whenever you buy replacement property or any property, you don't deduct all the acquisition costs. You always capitalize those costs. When you've got ancillary costs in connection with the acquisition of replacement property. For example, you buy property for $10 million and you pay $500,000 of legal fees. Well, those $500,000 of legal fees don't get to be deducted. They go into your basis for the replacement property. They are capitalized. So the fact that somehow I don't really understand this argument that says because they got to be capitalized rather than deducted, that's why they're treated as boot. That seems to us to be an incorrect statement of the law. And the FTB cites a whole bunch of cases, Woodward, Lincoln Savings and Loan, and Shaker Boulevard, which all stand for the principle outside the like-kind exchange context, that when you pay fees for the acquisition of property and new financing, that you've got to capitalize those fees. Well, that's certainly true, but that's true with respect to all expenses that are incurred with replacement property. You're buying new property. You don't get to write off all your expenses. When you paid $500,000 of expenses to buy a $10 million property and you paid your lawyer $500,000, you can't deduct those amounts. You've got to capitalize them, and your property has a basis of $10.5 million. So again, to us it's kind of like not really relevant. Because again, in fact, all expenses that are associated with the acquisition of replacement property or acquisition of any real estate, in fact, are added to the basis of the acquired property and do not get to be written off. But nevertheless, no one argues that all those expenses shouldn't be paid out of the QI account, because we all know they are. Certainly, I don't think the FTB would argue that $500,000 of legal fees associated with the acquisition of replacement property shouldn't be able to be paid out of the QI account. They certainly can. Again, you've got revenue rulings and case of Blott versus Commissioner, which pretty much stand for those concepts, for that proposition. And we also, as we mentioned in our initial protest, in our memo, is that any amounts that are paid in connection with the exchange under 1031 are allowed to be paid out of the QI account. And again, our argument here is that a loan, which is an absolute necessity in order to be able to finance the acquisition of replacement property, should be treated as a expense relating to or being in connection with the acquisition of replacement property, as set forth in the case of Blott versus Commissioner, and therefore should be allowed as to be paid from the QI account. That is because that expense was incurred in connection with the taxpayers' exchange, and that's why even if we do not prevail on the factual issue of whether the amount should be simply viewed as reductions of the loan amount rather than expenses paid for the QI account, even if they're viewed as expenses paid from the QI account, we don't see any reason why they should be treated as taxable boot. So that I guess rounds up our discussion of the expenses. Before I now respond to the appellant's respondent's opening brief. And just to summarize now the arguments with regard to the loan expenses, we believe factually, certainly on the 540,000 and arguably on the 341,000 as well. They really did not. They didn't come out of the QI account. It should not be viewed conceptually as expenses paid out of the QI account. They really should be viewed as taking out a smaller loan, because these are amounts being paid in order to access a loan. The lender is requiring these amounts to be paid, and therefore they should be viewed conceptually as reductions of the loan amount, not as expenses paid from the QI account. And that we feel that argument is compelling with respect to the 540,000, which in fact did not come out of the QI account. That in fact was just a reduction of the loan amount from the lender. But we believe there's an argument that same position should apply equally to the 341 because of the concept of cash being fungible. And it could have been done that way, and therefore it ultimately shouldn't make a difference how it's done. It should all be viewed conceptually as just simply borrowing a smaller amount, because that's what the lender is requiring us to pay in order to get the loan. And if we don't prevail on the factual issue, we believe on the legal issue, although it's not crystal clear and we can't point to an explicit case that addresses specifically expenses in connection with loans, we believe that under the authority that's out there, there certainly is a support for that position, because the authority allows you to access the QI account for amounts paid in connection with the acquisition. And because the acquisition of the replacement property in this case could not possibly have occurred without accessing loan amounts, we believe those loan amount fees paid in connection with acquiring those loans should be permissible to be paid from the QI account, and should not be treated as taxable boot if that indeed happened. Okay, so that's my initial presentation of our arguments. Now I'd like to get, because there were some differences between what the FTB initially argued versus what they argued when they presented their opening brief. So I just wanted to spend a bit of time now going through some of the respondents' arguments and our responses to the respondents' arguments as they developed later on in the respondents' brief, if I may. So again, for this, we'll follow the order of the respondent, and again, the respondent had cited to PLR 83-28011 to make the argument that loan fees are not amounts that are considered payable from the QI account. And again, as we pointed out there, that PLR is not talking about loan fees. That PLR is addressing other types of expenses, and for example, interest, food interest, late charges, pro rata rents, and rent deposits, and those are all things clearly which are not our position about but for the loan, the acquisition couldn't have occurred. That applies to loan fees. That argument does not apply to rent deposits, pro rata rents, late charges, and therefore that PLR we don't believe is relevant at all to the case that we're discussing here. I spent a bit of time. I don't know if we want to actually go to the exhibit, but if there was, that may actually be. Is there a way I could pull up on the screen one of our exhibits, or a little chart? Is that doable, or is that?
That's not necessary. All of the judges have the exhibit.
Okay, fine. Okay, fine. I'm on page. I just want to kind of go. This is kind of the FTB, and I'm looking now at page 3 of. Let me just see what exhibit it is.
Or if you'd like, you can tell us what the content of the exhibit is, and then we may already know what exhibit letter you're referring to.
Yeah. Okay, 1523. I'm referring to our appellant's reply brief dated August 17th, 2023. It's page 3 of our brief, which has a chart which comes actually from the uh, respondent. Just having trouble.
To confirm, you're referencing your um, August 17th, 2023 reply brief, page
Correct.
3.
Yeah.
All right, I see you have with sales purchase price of relinquished property and replacement
Correct.
property, correct?
That's it. Right. Right. And that's again, that's a chart that comes from the, and I think this again may be the source of why the FTB believes that there was boot here. But again, as I opened it up, and maybe it's easier. I'm a very visual person. Maybe it's easier if we actually look at the spreadsheet or the chart itself. This is the FTB is saying that the purchase price is 54.5 million. We borrowed 54 million, and therefore there's really only half a million of equity. Um, but again, as I mentioned earlier, and as I put it in our response, and I want to just verbalize this and present this as well orally, is that that's a misnomer, because if you're talking about the $54 million loan, that includes the entire 8.5 million of the second loan. That includes both the 4.5, the 4 million initially used to buy the property at closing, but that also includes the 4.5 million added on to that for the improvements later on. So if you're going to include that, you can't have a sale purchase price, which is basically the value of the property, as 54.5. You've got to increase that amount by another 4.5 million, because that amount goes up as the borrowed money, as the 4.5 million of escrowed funds are accessed and used to build to prepare to construct TI, to construct CapEx, to find tenants, to lease up the building. All that increases the value of the building. So it's a misnomer and very misleading to compare the 54 of debt to 54.5 of value or purchase price, which is effectively the fair market value of the property. Not only is it a misnomer, but a lender is never going to lend $54 million for a $54.5 million property. That's just the reality of the way the world works. They need, 80-20, 75-25 loan to value. And this only makes sense if the $54.5 million purchase price is actually 59 million, which is the reality, because you got to include the 4.5 million of escrowed funds that are later used to increase the value, or alternatively, take out of the 54 million, take out 4.5 million wasn't accessed immediately, and look at the loan as being only 49.5, not 54. But again, this may be the source of why the FTB is erroneously believing there was so much boot here, is because they're effectively comparing apples to oranges. And again, the property, when you look at the entire $54 million that was borrowed, which ultimately was in fact the correct amount, we had a building with a value or purchase price of 59 million, not 54.5 million. So I just wanted to make that point and make sure that was clear. And I think that again may be the source of why there's a belief on the FTB's part that there was no equity in the building, but that's just not true, because there was more money put into the building later on, which increases the value of the building. Again, as I mentioned earlier, the opening brief in the respondent's opening brief, the respondent's opening brief The respondent looked to section 1031 for the constructive receipt rules. Earlier, the FTB had said that they're looking to the general rules, but again, the rules, whether it's the earlier or the later, I think are all indicative of the fact that you look at whether there was substantial restriction on the taxpayer's access to the account, and if there was not such unfettered access to the funds, we don't have constructive receipt. And again, as we presented earlier, we don't believe there was unfettered access. We believe there was very limited access and very restricted access of the taxpayer to the escrow funds when they were deposited there at closing. One thing in its opening brief, the respondent says that the requirements are really illusory. Because, and again, they point again to the fact that it says, again, this was both in the initial correspondence indications from the FTB and in the opening brief. Again, they point to the fact that it says that the lender's approval of disbursements could not be unreasonably withheld, conditioned, or delayed. We addressed that earlier. It's the same argument, but again, that's only after the conditions have been satisfied. That's when that cannot be unreasonably withheld standard kicks in. Without taxpayer satisfaction of those conditions and requirements, that does not kick in, and therefore this is not to be viewed as illusory requirements or rubber stamping. No, that nothing happens. No funds are accessible unless the taxpayer went through a whole long laundry list of requirements that needed to be satisfied that were completely not in their own hands. And again, as we've showed, it's in the record as well. In fact, that 2.5, the 4.5 million was accessed over the years 2017, 2018, 2019. It was $1.3 million was accessed and was taken in 17, and then 3.2 million in 2018, 2019, and therefore the money had not been taken earlier. And again, as I mentioned before, if they could have gotten their hands on the money earlier, they would have. Because all my clients always want to get the cash and do business with the cash and want to borrow money as much as they can, as much loan to value they can get. And the fact that they didn't, to us, is indicative that they couldn't, because they would have if they could have. The respondents cited the Sullivan versus Commissioner, which again is a constructive receipt case that went against the taxpayer. But again, as we pointed out in our written response, and want to reiterate now orally as well, that was a very different case. The taxpayer in Sullivan lost because in that case there was no question the escrowed funds were not going back to the payor. The only issue there was, will the taxpayer himself be able to use the funds, or will he have to share some of them to pay some amounts he owed to his attorney and to his ex-wife? But either way, they're going for his benefit. Either he cuts a check to himself, he gets the money himself, or he may be required to share some of the funds to pay off some of his own obligations to his ex-wife and to his lawyer. Well, there, of course, that's an escrow, which we know in any event he's getting, or either he's receiving or people he owes money to will be receiving. They will ultimately be used for that taxpayer's benefit. So, of course, over there, those funds would be considered constructively received by the taxpayer. That is not like the case here, where if we wouldn't have met our conditions, the money would have gone back to the lender. We wouldn't have gotten it. So that case is not evidence of what how things should work in our case. Our case is very different than the Sullivan case, and therefore that is not really relevant to our case. In that case, the taxpayer had 100% legal entitlement. The only question was, does he get it himself? Does he need to share it with others to whom he owes money? Very different story than we have here. Then the FTB makes some arguments about the fact that the funds in the account served as security for non-payment. They functioned as a security deposit in the event EWVs would default on the underlying note. They have an immediate right, then the escrow holder would have an immediate right to apply the escrow funds to fully pay the loan. And then again, the FTB points to section 4C, which says that after the note is paid in full, then the money goes back, then EWV could access the money. So one of those points we've addressed earlier. The second point we didn't, in terms of the point that it's acting as security, again, we don't believe that's the case at all. Again, if there's a default, as in any loan, and you look at any loan agreement in the world, it'll be clear if there's a default on the loan, all hell breaks loose and all bets are off, money comes back, you're not accessing those funds anymore. That's all that provision says. That's all that it means. That's not any special benefit to the taxpayer. That's to protect the lender in case of default, that they don't need to then act upon the disperse funds upon meeting of the conditions. Once there's an event of default, they get to take all those escrow funds back and repayment of the loan. But if that in fact is constructive receipt, then pretty much every escrow in a loan context would be constructive receipt, which is obviously not the case. Regarding the fact that when the loan is fully paid, then they get the money. Well, of course. I mean, if they pay the full 54 million, then they get the escrow funds, because otherwise they'd effectively be double paying it. I mean, if they cut a check to lender for $54 million, effectively paying off the $45 million loan, 45.5 loan, and the full $8.5 million loan, well, then of course they get the escrow funds at that point. Otherwise they'd be out. They would have borrowed 54, and they would have paid back 54 and 62 and a half, which obviously can't happen. So then that's totally, again, a red herring here. The fact that once the loan is all repaid, the escrow fund, they get the escrow funds. Of course, that's exactly what it has. That's how it has to work, because nothing else would make sense in that context. We discussed again that they say, again, the FTB argues that the escrow funds were essentially EWV's property. They had constructive receipt of the funds because it was set apart for its use, and that it had dominion and control. Again, I think we've presented very, very strong evidence that that's not the case at all. We did not have dominion and control over the funds. The funds were not set apart for our use. They were in a special escrow fund that was accessible to the lenders, creditors, but not to our creditors, and therefore we don't see how that possibly could indicate constructive receipt. And again, the fact that upon a default they get to use they get to pull the escrow funds back, that's not considered our using it. That's just protecting the lender. Then we found it very interesting that in the FTB cited the examples in regs section 1.1031-1K-1 GB, examples 1, 2, 3, that those examples seem to indicate that determining whether escrowed funds are considered received or not turn on whether the escrow agreement limits the taxpayer's rights to receive the money in the escrow, and the taxpayer's immediate ability or unrestricted right to receive the money. And here the FTB writes that upon meeting the conditions stated in those agreements, in the escrow agreements, that's when they have access to the funds. So that seems to us to be a very, very strong admission of the FTB that in fact there were conditions attached to our agreement, attached to the taxpayer's ability to access those funds. Again, I'm quoting the language of the FTB, that the escrow agreements confer on EWV an immediate right to the escrow funds upon meeting the conditions stated in those agreements. Wow. That's very, very, we're very happy to see that language, because that tells us the FTB is conceding that there were conditions that needed to be satisfied in order for the taxpayer to access those funds. We agree with that, but that's exactly why those examples are not indicative of constructive receipt, because under those examples, the taxpayer needs to have immediate ability or unrestricted right to receive the money. And that is lacking here by the FTB's own statement. It's lacking here. And therefore, in conclusion, we believe strongly that there was no good in this transaction. We all, I think, are in agreement that it was fundamentally a good 1031, with all the time deadlines having been met and all the QI requirements having been met. The issues are solely whether was constructive receipt of whether there was actual or constructive receipt of the escrowed funds. We believe there were not, and there were very, very strong and significant restrictions that prevented the taxpayer from accessing the funds. And with respect to the loan expenses, we believe factually that they should be viewed as just reductions of the amount of the loan. And if the factual arguments are not accepted, we believe legally that the better argument is that those amounts should be treated as expenses that are permitted to be paid out of the QI account, because but for the loan, the closing on the replacement property couldn't have happened, and therefore they are expenses related to, are in connection with the acquisition of the replacement property, and therefore they should be treated as loan expenses or exchange expenses that can be paid from the QI account. My last point, again, is about the interest. Again, we're not claiming to have any specific point to any specific statute, but again, this case has gone on for a very, very long time. We believe our position is very, very strong, that there should not be viewed as any boot having been given to the taxpayer in this case, and therefore we respectfully request that interest be abated because of the taxpayer's strong positions of non-taxability.
All right, thank you, Mr. Lenz. With that, I'm going to ask my panel members if we have any questions for you about your presentation. I'm going to begin with Hearing Officer Elsom. Do you have any questions for Mr. Lenz about his presentation?
Yes, I had several questions, Mr. Lenz. So I'd just like to back up a little bit here and understand the entire transaction and what EWV intended to relinquish and acquire in exchange. So did EWV intend to acquire only the $54 million real property, or is its belief that the future tenant in common accounts and lease commission accounts and the construction improvement accounts were also part of the exchange, but because their access to those funds were limited and subject to restrictions, that it doesn't represent constructive or actual receipt of proceeds?
I mean, our replacement property is represented by the $54.5 million of the property the way it was on the closing date. End of 1031 at that point. We're not arguing that somehow we received another 4.5 and then we used that 4.5 to acquire additional replacement property, because we can see that is not allowed. In other words, that happened, in fact, way after the 180-day deadline, that construction. And construction doesn't work in a 1030. You can't use improvements to property in a 1031, mainly because it's too late. You already own the property. So we are not arguing that we received 4.5 million, but we spent it on improvements, and those improvements should qualify under 1031. If I got the question correct, we are not making that argument at all. We're saying we didn't get 4.5 million until after the exchange was done, and basically we closed on a property worth 54.5 million, and then subsequent to that, we borrowed 4.5 million additionally and built 4.5 million of improvements unconnected to our 1031 exchange.
Okay, so that was kind of my question. So basically, the 4.5 is completely separate from the 1031 exchange in the way this was planned and attempted to be executed. Correct.
We did not intend to use that towards our 1031, the 4.5 million. That was okay. We're not arguing at all that we somehow, we're not saying, oh yeah, we got the 4.5. That would be a whole different argument. Would be, hey, we got 4.5, but hey, we used it to build property. So what do you want from us? No, that argument does not work. We can see that. We're arguing we never got the 4.5 million.
And just to clarify, the argument is also not that your access to those $4.5 million funds were so limited that it would not constitute constructive receipt as part of the exchange. It's completely separate, meaning it's done borrowed after and accessed after the exchange.
Right. We did not have access before the exchange. Yes, we did not have access before. We didn't have receipt upon the exchange. We had receipt later on. We borrowed later on, and therefore it's unconnected to the 1031 exchange.
Okay. And the second question, I just want to reiterate or clarify the facts. So we have 3 escrow accounts. We have 1 escrow account for the replacement property. We have 1 escrow account for the tenant in common improvements and lease commissions. And we have 1 escrow account for the construction improvements.
Well, yeah, the escrow you're saying for the replacement property, that's like the standard. I think that's what we call the QI account, the qualified intermediary account. I think is what you mean. That's where the money. No,
I'm referring to where the funds went after, from the escrow account of the replacement property. So you had mentioned that there was just a momentary transfer of the 4.5 million from replacement property escrow, and then it went out, and I'm clarifying whether there was two accounts for that after it was transferred out. It looks like from reading in the briefing that there was one account dedicated by the lender to the tenant in common improvements and lease commissions, and then a second account for the construction improvements. So I'm just trying to clarify. Go ahead.
Oops, sorry, go ahead. You tried to clarify what?
Just trying to clarify the facts so we understand, the flow of the money and what exactly happened.
Yeah, so I'm a little bit unclear about this third escrow account. I'm aware of the two, the TI, there were two accounts that were two escrow accounts that I'm aware of are the ones where the 4.5 was housed, and the other money, as I understand, went to the seller of the replacement property.
Okay, so the improvement accounts were held in one escrow account, or excuse me, the improvement funds. The 4.5 is just one escrow.
No, there were two accounts. There was a tenant that's on the there was about 1.5 went to one escrow account, and then roughly 3 million went to 1.5 million went to the capex improvement escrow account, and 3 million went to the TI and leasing commission escrow account. I'm aware of those two. I'm not aware of a third escrow account where funds were going.
Okay, yeah, the third account I was referring to was the replacement property escrow account.
Oh, okay, yeah, to purchase the replacement property. Yeah, but I mean that as I understand, that money went to the seller of the replacement property, and the seller walked away with those funds, as I understand.
Okay. My next question is, if EWV intended to borrow money separately from the exchange to make future improvements to the replacement property and to pay lease commissions, why didn't EWV and the note holder establish an account completely separate from this exchange? I was wondering if you could explain the kind of the mechanics behind that, or why this was all looks like it was kind of commingled in the same sale. Why wasn't there a separate account set up either after the exchange or simultaneous with exchange for that 4.5 million?
Well, there was a separate 4.5. There were two escrow accounts which had the 4.5 where the money went, and those were separated out and were used for the later improvements. It's one lender, but that money, in fact, that 4.5 million was segregated from the money that went to buy the replacement property. So in fact, there was segregation of those amounts.
Okay, but it did still first go to, even if it was just for a millisecond, it still went to the replacement property escrow account first, correct?
I don't think it did actually. I think it went straight from the lender to those two accounts.
Okay.
I don't think it ever hit. I think it went straight. It would be no point in having a first. I think it went straight from the lender to those two accounts and sat there, and therefore were segregated from the other loan amounts that went over to purchase the replacement property and went to the seller of the replacement property.
Okay, and then on that note, it seems that there's some debate on the extent of control that EWV had over the funds, and I'm not clear myself whether those are the escrow funds of the replacement property, or you seem to indicate that those funds may not have ever even touched the escrow account and went straight to a separate account established by the lender. So there's some debate as to whether appellant EWV had control over those funds, and specifically, I'm referring to Section 1A of the tenant improvement lease commission escrow agreement. And that is on, I believe, Exhibit 17. And you can see on page 1 and 2. I'll let you go ahead and pull it up here before.
Yeah, pull that up. Yes. Which escrow agreement? FX or tenant improvements?
This is for the tenant improvement lease commission escrow agreement.
Yeah. What section?
So you've highlighted it's not a provision, but it states that the maker will separately deposit $993,099.50. And that, I'm assuming that's from its own funds separate from the exchange, and $2 million may be deposited from a portion of the loan proceeds. And this is in Section 1.A.
Yep.
And okay, so then you've highlighted a provision that says above section 1A, which states that the maker will deposit the $2 million from the loan proceeds. And then there's similar provisions for the account you're referring to as the CapEx account. So what I'd like to understand is whether this was contractually required by the lender, meaning they will, and this was at the direction of the lender, or may seems to indicate that, and I believe this may be what FTB is referring to, that EWV had some control over those proceeds, and it's at its discretion whether it pulls from possibly the fund of the replacement property or the loan funds, or maybe even its own money. So can you explain the difference in those two terms, or are you aware of what the differences are?
Shall versus the may is what you're referring to, sir?
The will versus the may.
Yeah. I don't have a full grasp of that, but I will tell you practically what happened is that the entire 4.5 million went straight into these escrow accounts and never hit the account of the taxpayer. So in other words, therefore, the language may have been a little bit unclear here, but as a practical matter, which is what's most important, what happened to the funds? Did the taxpayer ever access those $4.5 million of escrow funds? The answer to that is no. At closing, they went straight into the ANAC account, which is on that settlement sheet. Taxpayer never had the ability to get its hands on those funds. They went straight to the ANAC's account, and therefore it did not have actual receipt thereof. The lender wouldn't have let it had the money because it's not going to lend. It's not going to lend that money it's not going to count on it's not going to rely upon the taxpayer to return those funds to the escrow account. So it's going to make sure that it's all pre-wired so that at closing that money goes straight into the escrow account, and the taxpayer did not have access to it. Those funds.
Okay. And I did have a question about the bifurcation of this $8.5 million loan. And then there seems to be some debate between FTB and appellants regarding whether this loan can be bifurcated. Both loans, the 45.5 and the 8.5, I believe, are both secured by the same real property, which is the replacement property. And FTB has made a statement that the loan cannot be bifurcated, and the appellants replied that they don't see a reason why it can't be. Do you have any legal authority that shows where there's replacement property purchased, that a loan that's encumbering the replacement property may be bifurcated as amount that's separate from the exchange? Do you have any legal authority or analysis on that end?
I'm not aware of a legal authority, but I think it's to me it seems intuitive. In other words, if part of the loan I was able to access and I had actual receipt of, which is the 4 million, which we all agree we did access and used it towards the purchase of the building initially, well, that amount clearly, it was borrowed and we took that money, and we don't deny that. But 4.5 million of the same $8.5 million loan was not accessible and was deposited straight into escrow. That should receive different tax treatment, because different things happen to them. One amount was received at closing. One part, that's the 4 million, was received at closing and was used towards the purchase of the replacement property and was transferred to the owner of the replacement property, the seller. The other 4.5 was never accessed, never received by the taxpayer, never accessible by the taxpayer, but was escrowed immediately at closing, and therefore that should be. We don't see why that bifurcation is not absolutely logical and compelling.
Okay, and just to clarify, the entire $8.5 million is subject to the same terms, meaning the same interest rate, which I believe was 10%, the same payment terms, the same balloon payment. The bifurcation doesn't change the terms of the loan at all.
Right. The only thing that's different about them is the 4.5 is subject to the escrow and had to be escrowed and can only be accessed upon satisfaction of conditions, whereas the 4 million was not escrowed, went straight to the purchase of the replacement property, went to the seller of the replacement property to purchase the replacement property. So since they were used differently, they've got different tax treatments.
Thank you. And can you provide, just so we have a background on these tenant common improvements, were these referenced in the purchase and sales agreement for the replacement property, or how was this amount negotiated and determined that approximately $4.5 million should be borrowed to make these improvements? And were there work orders in place, or were these pre-existing, work that had to be done under pre-existing contracts for the tenants, or can you provide some background on that? And a follow-up question with that was, by looking at Franchise Tax Board's audit issue presentation sheet, they had referenced that EWV had attempted to obtain funding from a separate lender, and somehow that fell through. And I don't know if that was an attempt to separate this from the 1031 exchange or what the purpose of that was. But if you can just provide some background on those items, I think that'll be helpful for the factual development here.
Sure. On the first question, in terms of were these tenant improvements and or CapEx, was it part of the sale of the was that in the contract with the seller of the replacement property? I don't know factually. I would imagine the answer is no, because as far as the seller is concerned, it got its $54.5 million sale price and took the money and ran, and it's out of the picture. The buyer then, our client, EWV, then, for whatever reason, my understanding is wanted to improve the property, bought the property for the purposes of developing it, or of building it out, doing this more construction, leasing it up. And I believe that decision and all that had nothing to do with the seller of the relinquished property. I believe, although I haven't verified this fact, I believe that the answer is that that was just something which the buyer itself, our client, the taxpayer, decided to do. Perhaps the lender wanted it as well. I don't have the information that I can necessarily give you an answer fully, but I don't think it had anything to do with the seller of the replacement property. I believe it has to do with the taxpayer's desire to improve the property.
Okay, and then the purpose of the loan that was attempted prior to, or the financing that was attempted to acquire prior to the 8.5 million, it looks like EWV, according to the Franchise Tax Board's audit issue presentation sheet, there was an entity, DPG Investments, that EWV attempted to acquire financing from for these future improvements. Can you provide some chronology with that? And was that going to be separate from the exchange again? Or was that?
I know that there was out there, but I don't have any further information as to why that was done that way and how that would affect this. The fact that we ultimately went with this lender, I don't have any better information on that.
Okay. And would you like to provide the purchase and sales agreement for the replacement property for additional review, or?
We'd be happy to provide that. If Your Honor thinks that's helpful, we certainly be happy to provide that.
Okay. Yeah, I have no further questions. Thank you.
All right, thank you, Hearing Officer Elsom. Next, I'll ask my co-panelist, Judge Keith Long, if you have any questions for Mr. Lenz.
No questions, thank you.
All right, Mr. Lenz, I do have one question for you, and this goes back to the legal argument you made regarding the exchange expenses. You were mentioning you think that there's an argument to be made that those expenses, the payment of lender's legal fees and the loan prepayment fee or penalty, that there's an argument to be made that those amounts should be permitted exchange expenses. And in your argument today, it sounded like you might have been saying that it sounded like you were almost discussing the 1031 regulation safe harbors and kind of applying that to permitting exchange expenses. I'm wondering if you could talk about that more.
I was actually, what I was addressing was the case law, which under Blatt and the GCM that is out there. Let's get a hold of that. Yeah, I'm having trouble finding, but yeah, there's a GCM which kind of, and a revenue ruling and a court case, Blatt, which will basically say they're what all practitioners look to for guidance as to what's permissible exchange expenses, and it's really under that line of reasoning where the case, I think it's the Blatt case, which explicitly says that any expenses in connection with the exchange can be paid out of the QI account. And again, the argument we're making is because the loan is made in connection with the exchange, and but for the loan, the exchange or the acquisition of the replacement property could not have happened. Therefore, it's a valid exchange expense under the GCM and the revenue ruling and the case in the block case. I was not going to the regs on that safe harbors.
All right, thank you. I just want to restate to confirm my understanding. Your assertion is that the lender's legal fees and the 1% prepayment penalty were exchange expenses because they were, but for the loan, they would not have been able to purchase the real property. Is that correct?
That's okay. I'm not citing to a case that says that, but there's no case that says against that either. It's kind of an area that has not yet been fully developed.
I understand. Thank you. That concludes my questions. So with that, we are going to take a 10-minute recess before we move to Franchise Tax Board's presentation. We're going to go off the record during that time, and during that time, you will be returned to the waiting room in Zoom. So please don't leave Zoom. And with that, we are going off the record, and we will return at 2:45 p.m. Thank you. All right, welcome back. If everyone is ready, we're going to go ahead and go back on the record. With that, Franchise Tax Board, you have 60 minutes for your presentation. You may begin whenever you are ready.
Thank you. Good afternoon. EWV is a pass-through entity. In 2016, it was owned by 3 individuals, Alan Abady, Shan Hashem, and Farid Kanani, who, along with their wives, are appellants in this appeal. In 2016, EWV exchanged property in Pasadena, California for property in Renton, Washington, per Internal Revenue Code Section 1031. The first issue in this appeal is whether appellants have shown that respondent erred in determining EWV received non-like-kind property in its Section 1031 exchange. EWV had actual and constructive receipt of exchange funds, making the exchange funds non-like-kind property or taxable boot. Boot can be decreased by a taxpayer's exchange expenses. Exchange expenses are costs specifically related to the fact that the transaction is a Section 1031 exchange. They are transactional costs that relate to the disposition of relinquished property and the acquisition of replacement property. Loan costs are not exchange expenses. They are the cost to obtain a new loan rather than the direct cost of acquiring replacement property. Appellants cannot deduct loan costs from their boot in this appeal because loan costs are not exchange expenses. Therefore, the loan costs EWV paid with exchange funds cannot reduce the amount of appellant's proposed tax assessment. The second issue is whether appellants have established that they're entitled to interest abatement. Appellants state respondents should abate their interest because the case has been in process for a long time. As appellants do not meet the statutory requirements for interest abatement, respondent properly imposed interest in this appeal. EWV began this exchange with approximately $6 million in equity in the Pasadena property and ended with $500,000 of equity in the Renton property. This is an approximately $5.5 million difference. The exchange period spans from the day the relinquished property is transferred until the day the replacement property is purchased. The Fredericks case that appellants referenced was not within the exchange period because that case dealt with a loan on relinquished property before it was exchanged, while it was in contract, but not before it was sold, or not after it was sold. The funds dispersed at escrow are exchange funds, as the taxpayer has yet to receive the like-kind property. During the exchange period, EWV directed its QI to transfer about $340,000 in exchange funds to its lender, ANIC, to pay legal fees associated with its loan on the Renton property. Then the following amounts were dispersed at closing of the Renton property. About $4.5 million paid into 2 escrow accounts held by ANIC and $540,000 to ANIC as a loan prepayment fee. The facts of this appeal show respondent properly assessed proposed taxes on boot that appellants received in 2016 and properly charged interest. California conforms to Internal Revenue Code Section 1001, which requires taxpayers to pay taxes on gains from the sale of property. Most taxpayers pay taxes when they sell property. 1031 is an exception to the general rule. To qualify as a Section 1031 exchange, there must be an exchange of like-kind property that is held by a taxpayer for investment or use in a trade or business. Per Section 1031A1, if there is no exchange of property and the held for investment requirement is not met, the transaction is not eligible for Section 1031 treatment. Per Section 1031B, when a taxpayer receives non-like-kind property, in addition to like-kind property, the gain is recognized up to the value of the boot. Per Section 1031B, if a taxpayer exchanges like-kind property for other like-kind property and satisfies the general requirements of Section 1031, as was done in this exchange, but also receives boot, only the boot is taxable. Further, if a taxpayer receives exchange funds during the exchange period, the exchange funds become boot. In this transaction, EWV completed a Section 1031 exchange, but had both actual and constructive receipt of its exchange funds during the exchange period, making the exchange funds non-like-kind property or boot. Further, the loan costs are not exchange expenses and cannot be netted from the boot. Thus, the funds used to pay the loan costs are also taxable. It is the taxpayer's burden to prove that they completed a non-taxable Section 1031 exchange. Appellants have not met this burden. Okay, so I'm going to begin with actual receipt. And there are specific definitions of actual and constructive receipt in terms of a Section 1031 exchange. I want to clarify appellant's understanding of actual receipt in the terms of a Section 1031 exchange. A taxpayer is in actual receipt of exchange fund when the taxpayer actually receives the money, which appellants have referenced. But appellants forgot this prong of the law. A taxpayer is in actual receipt of funds when they receive the economic benefit of the money. EWV had actual receipt of exchange funds because the money in the escrow accounts was held as collateral for the $54 million loan for the Renton property, giving EWV the benefit of the money, and because EWV used exchange funds to pay loan costs. And then I'm going to look at constructive receipt. Again, constructive receipt is a distinctive term used in a 1031 exchange. Appellants have brief constructive receipt for the purposes of Internal Revenue Code Section 451. But FTB has always been very clear. We relied on the law interpreting Section 1031, not Section 451. And there's distinct differences between appellant's briefing of constructive receipt for Section 451 and FTB's position on constructive receipt in terms of a Section 1031 exchange. For a 1031 exchange, a taxpayer has constructive receipt of exchange funds when the money is credited to the taxpayer's account, set apart for the taxpayer, made available so the taxpayer may draw upon it. As the court in Klein v. Commissioner stated, the power to dispose of money is the equivalent of ownership of it. A taxpayer is not in constructive receipt of money or property if the taxpayer's control of its receipt is subject to substantial limitations. Courts interpret substantial limitations as a taxpayer being bound by contract to not use the funds. No contract prohibited EWV from using the money in the escrow accounts. It's not just that it's difficult to get the money out of the accounts because there are onerous conditions to get the money. You have to have no ability to get the money. EWV was in constructive receipt of about $4.5 million in two escrow accounts. Per the escrow agreements, EWV had the right to pay expenses, such as its mortgage, from funds in these escrow accounts. Further, the escrow agreements allowed ANIC to disperse money to EWV and would provide EWV with immediately available funds without constraints. An escrow agreement must limit a taxpayer's ability to gain funds, or it doesn't meet the qualified intermediary safe harbor provisions of Treasury Regulations Section 1.1031K-1G4 little iiib. And that's something that appellants have not shown, that the escrow agreements have not limited their ability to get the money. But further, specifically, Section 3 of both escrow agreements require ANIC to approve disbursements and stated that ANIC's approval could not be unreasonably withheld, conditioned, or delayed, meaning EWV had the ability to access the funds and there was no constraint on its use of the funds. The fact that EWV could receive the money if it met ANIC's conditions, show that EWV had constructive receipt of the funds, as the funds were made available so EWV could draw upon them. EWV also had constructive receipt. Oh, I just want to add, a taxpayer's own limitations on escrow accounts does not make the escrow account a qualified escrow account. It must have that limitation on that taxpayer's ability to use the money. EWV also had constructive receipt of exchange funds because EWV directed its QI to send about $340,000 in exchange funds to ANIC to pay legal fees. And EWV paid $450,000 from exchange funds to ANIC for a 1% prepayment fee on its $54 million loan. In their opening brief, appellants described these expenses as loan costs, which is important. The payment of these loan costs was directed by EWV. Therefore, EWV had constructive receipt of the funds. Actual and constructive receipt of cash from a Section 1031 exchange is not like-kind property, but boot and taxable. In contrast, certain exchange expenses paid at the closing of a sale are exchange expenses. Using exchange funds to pay exchange expenses is not taxable. Legal guidance delineates expenses in a Section 1031 exchange as either exchange expenses, which are not taxable, or non-exchange expenses, which are boot and taxable. Treasury regulations do not include loan costs as exchange expenses. Specifically, Treasury Regulation Section 1.1031K-1G7 ii says transactional items that relate to the disposition of the relinquished property and the acquisition of replacement property and appear under the closing statement as the responsibility of the buyer or seller are not taxable. The Treasury regulations give examples such as commissions, prorated taxes, recording or transfer taxes, title company fees. Expenses to get money are not the cost of the acquisition of property. These expenses are different. Prepaid loan fees and attorney fees related to a new loan are not closing costs because they do not customarily appear on the closing statement. An easy test is to ask if the expense would exist if the transaction was a cash-only deal. For example, PLR 8328011 that appellants reference shows expenses that are not related to an exchange, to the exchange specifically, are boot. Loan costs are not related to an exchange. They're the personal expenses of the buyer. Loan costs are the cost to use borrowed money and not transactional costs that relate to the disposition or acquisition of property. As such, loan costs are not exchange expenses because they cannot be subtracted from boot. As Andover Realty Corp instructs, expenses incurred from borrowing or financing are capital expenditures and properly amortized over the life of the loan. This shows that it's not a deductible expense that can be subtracted from boot. The funds that EWV had access to in the two escrow accounts and the amounts EWV paid for loan costs are non-like-kind property and taxable. The loan costs are not exchange expenses. Therefore, EWV owes taxes on the income of approximately $5.5 million and an additional LLC fees of $9,290. This income flows through to EWV's owners, who owe taxes on their capital gains accordingly. In regards to the second issue, interest is not a penalty, but merely compensation for a taxpayer's use of money after it should have been paid to the state. The imposition of interest is mandatory. There are three ways to obtain statutory relief from interest: an unreasonable error or delay, reasonable reliance on written chief counsel advice, or a waiver for extreme hardship. Appellants have the burden of proof and not showed that they met the statutory requirements for relief. Merely stating that it took FTB a long time to complete a case does not qualify a taxpayer for interest abatement. Appellants bear the burden of proof to show that their entire transaction met the requirements of Section 1031 exchange, such that they did not receive boots. Appellants have not met this burden. Further, appellants have not shown that they are eligible for statutory relief from interest. Respondent properly proposed a tax adjustment to include boot from the sale of the Pasadena property in appellant's taxable income in taxable year 2016. Thus, respondent's notice of action should be upheld. I'm available for any questions. Thank you.
All right, thank you, Ms. Kudik. I'm going to go ahead and start off with just a couple questions for you about your presentation. First, I'm going to ask you, I want to confirm my understanding. It sounded like the Franchise Tax Board position is that there is constructive receipt if a taxpayer has the ability to get money out of the escrow funds, even where those funds are subject to conditions or restrictions. Is that correct?
Yes.
Now, I believe Mr. Lenz has discussed the case Fredericks v. Commissioner with us. Can I ask how that statement, that position of franchise tax boards, how does that reconcile with the tax court's holding in Fredericks?
Well, Fredericks was about relinquished property, and here we're talking about replacement property. So there's a distinction.
All right, thank you. Would you like to discuss that further, or is that?
If you would just give me a second to look at my notes.
Absolutely, that'd be fine.
Okay, thank you. So in Fredericks, the exchanger refinanced the relinquished property 2 weeks after executing a contract to sell the property. So it was relinquished property. Here, this is replacement property. So it's different because the exchange period begins when, as I stated, when the relinquished property is sold and until the day the replacement property is closed. So in Fredericks, it wasn't during the exchange period that they took the money out of the property. And I believe, yeah, I believe they found for the appellant in that case, right? They found for the taxpayer in that case.
Yes, that's also my understanding.
Yeah.
Thank you. That answers my question. And then my next question for you is, I want to confirm my understanding of FTB's argument regarding the ability to offset boot based on whether a cost is capitalized or deductible. I'm curious if you have any thoughts about the GCM 34895. I believe in that GCM, it was determined that commissions were able to offset boot, and were considered exchange expenses that were also added to boot. Does that have any bearing on FTB's position, or have I misstated the GCM conclusion?
It was added to basis, right?
Yes, I'm sorry, it was added to basis. Thank you.
Right. Well, I think there's a distinction because it's a question of transactional cost and what's the definition of transactional cost. And here, our position is that loan costs are not transactional costs because you can close the buying and selling of property with cash. This loan cost is the cash for the appellants to borrow money, and it's very distinct from what is absolutely necessary to get a property sold, like paying the taxes, doing an inspection, commissions for people who are working in the transaction. But loan costs it's a personal expense for the appellant, for the taxpayer.
All right, thank you. I understand. With that, I'm going to see if my co-panelists have any questions. I'll begin with Hearing Officer Elsom. Do you have any questions for Franchise Tax Board about their presentation?
Yes, I did. So Franchise Tax Board, I just wanted to address first, you had made a statement that approximately $6 million of equity was realized in the sale of Pasadena property, and then about $5.5 million was transferred into the Renton property. Was that accurate? Did I hear that correctly?
Yes.
Okay. Now, after that amount was transferred, my question is again regarding the bifurcation of the loan. I wanted to ask, do you have any legal authority that shows that an exchanger cannot bifurcate a loan that's secured by a replacement property? Has there been any analysis on that end?
I'm not really quite sure what you're talking about with bifurcated loan. I mean, they took two loans out, right? There wasn't one loan that was cut in half. It was two distinct loans, right?
So appellant's arguing that the $8.5 million loan was bifurcated, and a portion of that went directly into an escrow account for tenant common improvements and lease commissions and some sort of construction in process, which he's calling CapEx. So they're arguing that that is separate as effectively from the exchange.
Oh no, that wouldn't be separate because it's all exchange funds, right? So when they, let me go back to my presentation on my beginning of my presentation. So you have to look at what is the exchange period, right? It doesn't matter what kind of loans they're getting. It's like when you sell the relinquished property and before you buy the replacement property, all the money that comes from the relinquished property is exchange funds. And so, however they tried to structure or hide those exchange funds, they were still funds from the 1031. And so I don't think it really matters if they used it to leverage loans or they used it to buy property or to put into a escrow account. That money was exchange funds, and unless it went directly into the 1031 or as exchange expenses, it's taxable.
Okay. I think that answers the question.
Yeah.
And then the next question, I want to make sure that I understand FTB's arguments. So you had mentioned because equity was rolled in from the Pasadena property into the rent and replacement property, and this $4.5 million that's going towards these future improvements, that's secured by the replacement property. That's actual receipt. Did I understand that correctly? Because this is for the benefit of the taxpayer, and I believe you'd mentioned specifically because that $4.5 million portion is secured by the replacement property, which is there's no dispute as to whether that is exchanged property.
I don't think it was a question of what it's secured by. I think it was money that was taken during the exchange period that were exchange funds and was put in an escrow account, and they had the ability to take the money out of the escrow account and not only take it out, it was used for their benefit to secure their loan, to pay their mortgage. I mean, it was basically their money, and there was no escrow agreement that said they couldn't touch the funds.
And on the constructive receipt.
Oh, I'm so sorry. I can't hear you.
Are you able to hear me now? Can you hear me?
Yeah, now I can. Yeah.
Okay. I want to make sure I understand the constructive receipt prong of the argument. Is that based upon the language that was included in the $4.5 million draw, where is FTB's assertion essentially that the appellant directed those funds into an escrow account, or are you referring back to the legal fees of $341,250 that it looks like appellant directed from the funds, and you'd mentioned the $540,000 prepayment fee on the replacement property as well. Is it all of those items that why you're asserting constructive receipt, or is it just a few of those? Or
No, our position is that appellants had constructive receipt of all of the money.
all of the money? Okay.
Yeah.
And is that supported by? Sorry.
I think I would refer you to Klein v. Commissioner, whereas the power to dispose of the income is equivalent to ownership of it. So they had the right to draw upon the money. So they had constructive receipt of the money.
Okay. And then I'm looking at the exchange facilitator agreement. This is Exhibit K, and we're page 1 of Exhibit K, and it does reference that appellant is directing payment of $341,250 to looks like a Wells Fargo account, which is for the legal fees. But then it's appearing to indicate under, I believe it's provision 12, that exchangers' access to the remainder of the proceeds is limited. So again, has FTB reviewed that provision or taken that into account in analysis that the appellant had control of all or constructively received all of the proceeds?
Well, it's in an escrow account, right? So I think if you go back to the Treasury Regulations Section 1.130K-1G4 IIIB, they have to say that they can't have access to it.
So the access you're referring is to the replacement property escrow account,
Right.
rather than the facilitator's intermediary account.
I'm not sure what you're talking about. He directed the $340,000 to for the prepayment. Is that what you're asking about?
Sorry. I'm referring to, can we go to Exhibit K, page 1? And I believe this is the facilitator agreement. It says First American Exchange Company. Was that the facilitator, or is that the escrow company?
The QI?
That's the QI in Exhibit K?
No, I don't know. I'm asking you, is that what you're asking? Who the QI was? Is the you said facilitator, you mean QI? Is that the same?
Yeah, exactly.
Okay.
It says, the first provision says FAEC, which is First American Exchange Company, is presently holding certain funds, and the exchange proceeds to be utilized to acquire and convey certain replacement property exchanger as provided in the exchange agreement. Now, am I looking at the exchange agreement here, or is this the escrow company here?
I don't know, because I can't get to the hearing binder. It's not working. Okay, it says it's something went wrong.
We can address it later if you're not able to access the information. I'm just trying to understand the entirety of the constructive receipt argument.
Ms. Kudik, it looks like we've lost your video feed. If there's a specific exhibit, perhaps we can have our staff send it over to you so that you have it available. Mr. Cunningham, do you know if Ms. Kudik is still online?
It looks like she's. Let me check with. Let me send her a message and check.
All right,
Give
thank
me
you.
1 second. And I also sent her over the document via email, so.
Thank
let
you
me
very
see-
much,
Let
Mr.
me see if
Cunningham.
she's still online.
Can you clarify, Mr. Cunningham, if Exhibit K is the facilitator agreement? Or is
Exhibit
that,
K, that looks like First American Exchange Company, I believe, is the QI.
okay. Yeah, so my basic question was whether, it appears that a portion of the exchange proceeds was accessed by appellant for the 341, 250, but the remainder was restricted. And I was asking that question specifically with respect to constructive receipt of the entire proceeds. That's why I asked that question.
Okay, let me look. And
We
Judge
will wait just a
Long,
few minutes for
she
Ms.
says
Kudik.
she can't get in. She says, no, I can't get in.
Does she have internet access and she's unable to access the Zoom?
Let me find out.
All right.
Or I mean, I could have her come in with me and we could work off the same video if that would be okay. Or I would have to go see, what the issue is.
Right now, it looks like she's just exited the Zoom meeting and then she should be able to rejoin.
Okay.
If you need to work out of the same office, that's absolutely fine with us. But we don't want to move forward with the hearing without Ms. Kudik present. So
Can
we're
we
just
take a 5-minute, can we take a 5-minute break and I will go
absolutely.
resolve it?
Absolutely. With that, we're going to stop the record. We're going to take a 5-minute recess and we will return at 3:25 p.m. Thank you.
Thank you.
All right, welcome back all. I'm going to look to my co-panelists and my stenographer to make sure we're ready to go back on the record. All right, with that, we are back on the record. When we had last left off, Hearing Officer Elsom had been asking Franchise Tax Board a question. I'll let Hearing Officer Elsom restate his question for Franchise Tax Board, please.
We can move on from that question. My question really was just directed at what specifically FTB was relying on to state that appellant had constructively received exchange proceeds. Was that the $341,250 payment of legal expenses? Was that the language where appellant may have directed proceeds into these separate accounts for the tenant and common improvements, lease commissions, and construction improvements? I was just trying to obtain a general understanding of the exact argument for constructive receipt.
Oh, I would say it's Exhibit M and N, which are the escrow agreements. And those escrow agreements state that the taxpayer could use the funds to fund collateral loan fund an additional collateral loan to ANIC, and also the funds could be a source of immediately available funds to EWV. That's in the opening brief, footnote 13, and it's Exhibit M, pages 2, 5, 6, and 7. That's the tenant improvement escrow agreement, and then that language is kind of mirrored in the capital improvement escrow agreement,
Okay.
which is Exhibit N.
Thank you.
Yeah.
And I did have one final question, and that is, if FTB taxes $4.5 million as proceeds, as gain, and then appellant uses that money to pay lease commissions that presumably are expensible and make improvements that would be either depreciated or amortized, it feels like the economic outcome matches the tax outcome. But if appellant is then paying those funds back to an unaffiliated lender, appellants feels like they're being double taxed here, because they're not only paying tax on the $4.5 million, but they're then having to pay that back to the lender with no corresponding tax deduction. Has FTB analyzed that end of the tax outcome or the tax effect of treating this as proceeds rather than a loan that's being paid back, and the appellant's not receiving a benefit for the payments it's making, or tax benefit for the payments it's making to the lender?
Why wouldn't it be able to deduct the payments it made to the lender? That's what normally happens, right? They deduct the interest because it's a loan.
Well, the principal, the entire $4.5 million, is what FTB is proposing to tax, though. And that entire amount, if I'm understanding correctly, has to be paid back to the lender. So it feels like as if appellant could potentially be double taxed here, because they're taxed on that $4.5 million as if that was gain, but then they're having also to pay that back to the lender, but they're not receiving a tax deduction for that principal that they're paying back.
Oh, they're getting a tax deduction for the interest. No, because that's not part of 1031 law. I mean, the economic benefits are, they're already getting a lot of economic benefits from doing the Section 1031 exchange. And we didn't deny the Section 1031 exchange. We're just taxing what is boot. So they're already, I think it's that famous quote that a Section 1031 exchange is a benefit to the taxpayer, and everything within a Section 1031 exchange has to be done correctly because it's such a huge benefit for the taxpayer.
Okay.
Yeah.
Thank you. I have no further questions.
All right, with that, I will pass it to my last co-panelist, Judge Keith Long. Do you have any questions for Franchise Tax Board?
No questions, thank you.
All right, with that, I am going to give Mr. Lenz 10 minutes for rebuttal. Mr. Lenz, I will ask you to please speak slowly, and you may begin whenever you're ready. Thank you.
Thank you very much. I just want to first to respond to what Hearing Officer Elsom had asked before. I have confirmed while we had a break that the money in the escrow account never actually hit the taxpayer's bank account. They went straight. Basically, the lender is the escrow agent, and they basically withheld the 4.5 million and didn't disperse it yet. That's the concept. So it's not like it actually went into our account, and then we, at closing, it actually hit our account for a minute, and then we transfer it from our account back to the lender. The lender just withheld the 4.5 million, and so it dispersed 45.5 million for the one loan. It dispersed 4 million out of the $8.5 million of the second loan, and it held on pursuant to the escrow account, the escrow agreements, the other 4.5 million. Now, had it actually hit our account, I don't think the result would be different, frankly, because it was pre-wired. If it came in, it had to come back out. In other words, it was all pre-wired. There's no way the lender would have said, let the taxpayer actually run away with the money. It had to be used for these purposes. It had to go to the escrow. But as a matter of fact, it had not hit our accounts. It was just withheld by the lender. Just responding a couple other points that FTB had made. I mean, according to the FTB's economic calculations, the taxpayer should have walked away with $5.5 million of cash in its pocket. I mean, that's because they're saying that we only had $500,000 of equity, and we acknowledge there was $6 million of equity in the relinquished property. And the way it works is that, the only way that there's boo is if the taxpayer actually walked away and didn't use all the proceeds. But if you go through and according to the FTB's calculations, only $500,000 was reinvested. So that would mean that $5 million in the qualified intermediary account should have gone out and a check should have been written to the taxpayer, but that never happened. And I don't think anyone's claiming that happened. So that money, that proves effectively that the entire amount of equity was rolled over into the replacement property, because the taxpayer did not walk away with any amount of that money, which would have been compellingly have had to have happened had the calculations of the FTB been the facts on the ground. I think there also some of the back and forth. There may have been some, or some of what the FTB was presenting. There may be some confusion between the escrow account versus the qualified intermediary account. And FTB mentioned the regulatory safe harbors and the qualified escrow rules there. The qualified escrow rules in the regulatory safe harbor of 1031 are totally nothing to do with our escrow accounts. There are different ways of doing a deferred Starker exchange, the three-party exchange. One of them is a qualified intermediary, which is what we've used. Alternatively, you could use a qualified escrow or a qualified trust, which we did not use in this case. So those regulations about the safe harbor for a qualified escrow are unrelated to what we're talking about. We went with the QI and with the qualified intermediary approach, and separate and distinct from the qualified intermediary account, which is where the proceeds were held, there were these separate escrows which were funded at the closing of the replacement property purchase. Nothing to do with the money that was in the QI account, just two totally separate concepts. And therefore the 341, which came out of the QI account. I mean, I believe ANIC is both the qualified intermediary and the lender here, but totally separate accounts. The 341, we acknowledge, came out of the qualified intermediary account, but that has nothing to do whatsoever with the escrow accounts that were set up those escrow accounts were set up at closing of the replacement property. Totally disconnected from the QI account from where the 341 was paid. And again, the 540 wasn't paid from any of those places. The 540 just was a reduction of the loan proceeds received from the lender, and wasn't taken out of the QI account and was not taken out of the escrow accounts. They were just deducted from the amount of the loan that was paid over to us. If I understood FTB properly, I think what Ms. Kudak was saying was that And that there was, it doesn't really matter. I think she's acknowledging that there were multiple restrictions on accessibility of the funds in the escrow account. But I think if I understand FTB correctly, what Ms. Kudak is saying is that it doesn't matter the fact that there was any way whatsoever that the taxpayer could access the funds, even if it was through third parties and things that were not necessarily in their hands. It doesn't matter, because I think if I'm understanding FTB's position correctly, I think FTB is saying that the fact that at any point in time in the future, the taxpayer could access those funds, even if it meets those conditions, that alone means that those escrow funds are constructively received. And we fundamentally disagree with that. That we don't believe that is the correct statement of the law. There's no question, we all agree, I believe, let's say a week after the closing, certainly there's no problem whatsoever with the client, the taxpayer, then financing the property and taking cash out. That's fine. And the only issue for us is at the day of closing, before the 180 days were up. That's what's relevant. Before the 100, did it have access upon the closing of the replacement property? At that point in time, did it have unfettered access to the funds in the escrowed accounts? And the answer to that is a resounding no. The fact that in the future, it can do things and satisfy conditions that will then allow it that will allow it to then access the funds. That doesn't make it constructively received upon the day of the replacement property receipt, and therefore we don't believe that would result in constructive receipt. Wanted to point out as well that again the FTP in the order report, and I'm happy to cite to it, did explicitly argue that mentioned the bifurcation and said that the fact that the 4 million was used for the replacement property and 4.5 million was for capex. That was the FTB was saying that bifurcation is not permissible, and we don't see any reason why that can't be permissible. It's all part of one loan, but that one loan was handled differently. One part of it was dispersed immediately. The other parts were not dispersible, were not accessible till a much later point in time. And the other point is that in terms of the FTB, I know in the opening brief asserted that 451 is not the place to look for the constructive receipt rules. Rather, the FTB argued in the opening brief that it's the 1031 context that should be looked at for constructive receipt rules. But that was not its position in the order report. In the order report, it said specifically, I will quote. In the order report, page 19 of the order report, the FTB said, in the present case, regulation section 1.1031 K1-F1 and 2 with respect to actual and constructive receipt of the exchange proceeds would not apply here. In this case, we look to general constructive receipt rules as it would apply to cash basis taxpayers. And that, again, that was a point where there was a bit of a pivot later on. The IRS took a different position. But again, either way, I think it doesn't change our position that under either one of those sets of rules, you need unfettered access. You need to have the ability to access the funds. They have to be usable for your benefit immediately in order to be considered constructively received. And we don't. That is, it's definitely not what happened in our context over here. Again, I think there was mention again. The FTB mentioned once again here that under the agreement. Under the escrow agreements, that the funds in the escrow were able to be used as security for the lender. Well, that's not a benefit of the borrower. That's the lender. The lender is looking to protect itself. I mean, as lenders are always looking to do in all these documents, they want to make sure they are as fully protected and as fully collateralized and the loan is as secure as possible. So the fact, again, that the documents say that upon default, the lender is permitted to pull back the escrowed funds. I mean, again, that is absolutely typical and does not in any way show that the taxpayer would have preferred not to have the lender have that access, but that's something that the lender demands. So that and it does not show that that was available. Those funds were available for the benefit of the taxpayer in no way, shape, or form. That really shows that the lender demanded that, and as is expected and typical, those rights in order to protect its position vis-a-vis the escrowed funds. But again, that's I think, summarizes our argument.
All right, thank you, Mr. Lenz. With that, I'm going to ask my co-panelists if there's any final questions for either party. I'll begin with Hearing Officer Elsom. Do you have any final questions?
I have no further questions. Thanks.
All right, Judge Keith Long, do you have any final questions?
No questions. Thank you.
I as well have no final questions. I want to thank both parties for your presentations today. This case is submitted. It is April 24th, 2025. The record is now closed. Again, I'm thanking everyone for participating today. The judges will meet to deliberate and decide your case. We will issue a written opinion within 100 days from today. And today's hearing in the appeal of EWV LLC et al. Is now concluded. And this is the last hearing of the day, and that will conclude our hearing calendar.